Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3070, United States of America versus Robert Kijakazi, appellants. Mr. Kirsch for the appellant, Mr. Hobel for the appellee.
Good morning, counsel.
Good morning.
Mr. Kirsch, please proceed when you're ready.
Good morning. May it please support Stephen Kirsch on behalf of Robert Packer. And let me start out by saying that I fully appreciate the posture of the case. Mr. Packer has served his sentence that was imposed by Judge Nichols, and there was no supervised release as part of the sentence that was imposed on him. There does remain, however, a collateral consequence, which means the case is not moved. And the collateral consequence was the imposition of, whether we call it a fine or whether we call it restitution, but there was a monetary component to the sentence that was instituted or that was made part of the sentence. And we go back through the trial record.
Can I ask that was the restitution?
Yes.
$500 restitution?
Yes.
Well, that restitution is paying back sort of to the victim the damage caused. And that was due to his presence and participation at the Capitol, which wouldn't change. What evidence is there that turned it all on the length of his sentence?
Well,
But he would have had the same $500 restitution even if he'd gotten, as you had, as Counsel below had asked for, no sentence, no prison sentence at all.
The amount of the restitution is discretionary, not a mandatory amount. The only mandatory assessment was the $10 assessment. So Judge Nichols had discretion to give a different amount of restitution. And I understand that it was part of the plea agreement that he agreed to restitution in the amount of $500. However, that was agreed to before Mr. Packer was made aware that this was an illegal sentence in violation of his First Amendment rights. So even
That was
though,
before the sentencing hearing.
yes,
And the restitution is, does that go to the architect of the Capitol, or where does that money go?
it goes to the architect.
For damage caused by his presence
Yes.
there. So it has nothing to do with the length of his sentence.
It's not the length of the sentence. But it still is part of the imposition of the sentence. And I would emphasize to the court that where a trial court imposes restitution, there's a whole procedure that's outlined in the United States Code. It's 18 United States Code 3664, where there's, before a sentence is imposed or restitution is imposed, there are requirements that the government has to introduce evidence, the defendant has to introduce related to his indigency or his assets, and there has to be some sort of way to value the loss for the restitution because it is compensatory, but as the Supreme Court has said, it's also punitive. So there's two parts to it.
Is one of those factors the length of the sentence imposed in calculating restitution? Does the length of the sentence?
No, the length of the sentence does not matter in terms of the imposition of the sentence. So we would submit to the court that.
But have you considered sentencing guidelines too, that to the extent that you have a sentence of a certain length, later on it could impose certain amounts of points, whether it's 1, 2, or 3, because you would have now had that prior sentence that could then make you have a higher guideline sentence the next time.
Well, that's correct. But as Judge Nichols acknowledged, everyone agreed, sentencing guidelines in this case were not an issue because it's a class.
Yeah, I understand that, not for here, but I'm
Right.
saying the fact of having the conviction and then the sentence for another period later, then this becomes on the record and is a consideration for a higher sentencing guideline calculation.
Yes, it does. Yes,
Okay.
it does. I mean, it follows Mr. Packer down the road if he's ever convicted in the federal court. Certainly that would show up as part of his.
But are you relying on that to counter mootness, that potential consequence? Or are you relying on that? I mean, what you started with was restitution,
Right.
which I understand. And on this one, is the prospect that someone might commit another offense something that we take into account in deciding whether a case is moot because the sentence has been served? Or do we not factor in the prospect that someone will commit another offense, in which case there would be sentencing repercussions down the line?
Yes, well, a primary argument is that the collateral consequence, number one, is the fact that there's restitution and it's a discretionary amount. But in response to Judge Child's question, I agree that this is something that should Mr. Packer again come before a federal court for sentencing on another matter, this will be a part of his sentencing guidelines.
It will be. It could be. I guess all I'm asking is, are you relying on that second part of it in arguing against mootness, or are you only relying on the restitutionary award of $500?
We're incorporating both.
Are you relying on
Yes.
the second part too?
Yes.
So your read of mootness principles is that we do take into account the possibility that the defendant might commit another offense, deciding whether the fact that the sentence has passed makes the case moot?
Well, there is a potential. That's correct. I mean, there is a possibility, there's a potential, but it's not. I would submit that the restitution order is definite. We know that there is an order of repayment, and that has not yet been satisfied. So to this day, whether we call it restitution or we call it a fine, still a requirement imposed on Mr. Packer. And I'd also know for the court that reading the trial record, it's very ambiguous what Judge Nichols was saying. I understand he mentioned restitution at the sentencing hearing, but if you go back in the plea agreement itself, he talks very specifically, or the plea agreement talks very specifically about a fine, and then talks generally about restitution. And Judge Nichols also said in his sentencing allocution to the defendant, he said, well, I've imposed fines as low as $500. So clearly the notion of a fine was on his mind, and I believe that the record demonstrates that he conflated it. But we also take the position that it really doesn't matter, because the imposition of a monetary sanction is an adequate collateral consequence, such that this case is not moot. And getting to the substance, getting beyond the procedure and getting into the substance, there's no question, no one's disputing that the T-shirt bearing the words Camp Auschwitz was utterly offensive, and it was utterly offensive. But Mr. Packer was still entitled to protect your First Amendment protections. And even though Judge Nichols sentenced Mr. Packer within the guidelines, he still had discretion. Now, Mr. Packer was sentenced to a period of incarceration of 75 days. He could have given him a lesser sentence, or he could have given him probation.
What's your argument as to the appeal waiver? Because that was raised by the government in its brief, and then we didn't get a response from you about the appeal waiver.
It's not waived, because our argument is that the sentence was illegal because it violated his First Amendment rights.
Is that your only reason? And I ask that because any plea and plea agreement should be knowing, voluntarily, and intelligently waived. And here, a plea agreement in and of itself doesn't get us, not necessarily do we rely only upon that, but you're only going to rely upon the plea colloquy by the judge, but there was no transcript, attached here.
Right, but our position is that when they went in for the plea, and they went in and they submitted the paperwork, everyone assumed that this was going to be a constitutionally permissible plea. And it's after the plea is entered that the government files its very lengthy sentencing memorandum and highly emphasizes the T-shirt multiple times, talking about the Camp Auschwitz T-shirt. And then at the sentencing, Judge Nichols made very specific references.
But isn't it in the nature of an appeal waiver that it comes before sentencing that you don't know whether there's going to be a legal problem that arises in sentencing? And everybody understands that. But part of the bargain is, even though we don't know what the legal problem is that might arise, waiving the ability to challenge that on appeal.
I agree with Your Honor that this is something that you expect going into a plea, but you don't expect that the judge is going to violate the constitutional rights. So an appeal waiver is only good if the plea itself and the allocutions and the judge's sentence are legal. When they're illegal, then the plea waiver no longer is valid.
So if you thought that Judge Nichols, that the district court misapplied the guidelines, and we wouldn't know that at the time that the appeal waiver was entered into, but then it comes to pass during the sentencing hearing that there's a misapplication of the guidelines, would you be arguing, well, nobody would have anticipated that there would have been a misapplication of the guidelines, and therefore the appeal waiver doesn't apply because everybody assumed that it would be done strictly in accordance with law, including the statutes, including the guidelines.
I would argue that, and that specifically is permissible. And that's in virtually every plea in the district court, is that if the judge goes beyond the guidelines or doesn't follow the guidelines or doesn't give a good reason for going beyond the guidelines, that is appealable. And
But here, when you, and again, you did not attach the transcript, but here we would be looking to the plea colloquy to understand that even if comments are made earlier or there's some reference to the T-shirt, it's at the time of sentencing when the judge kind of goes over the factors as to how they got to that particular sentence. Was that a consideration with respect to the T-shirt?
yes, and we reference that in the brief, and I pointed out specific
No,
parts.
but what I'm talking about, you can have comments earlier on, you could have it in writing, you could have it orally at the plea colloquy. But when you get to the point of actually sentencing and the judge is providing their reasoning and their rationale, and there's no mention of the T-shirt at that time, would that make a difference?
Well, it could make a difference, but in this case, at the sentencing hearing, I mean, the judge specifically referenced the 3553 factors, went through the 3553 factors, but then he went into the T-shirt. And he assigned a nefarious intent to the T-shirt. And he said it's less for us to infer what the T-shirt means. And the best,
And you would suggest that that was occurring right at the time of the sentencing?
Yes.
Like as part of the factor?
yes. And the best example I could think of, I mean, is that if Mr. Packer had been wearing a T-shirt that says, "I support the First Amendment," if the words on the T-shirt were that, it would not have been a reference in the sentencing memorandum to those words. And now it would not have been a reference by Judge Nichols when he imposed sentence to those words. It was strictly because it said Camp Auschwitz on it. And on the back, there were other offensive words. And there's no evidence in the record that T-shirt was being worn to incite the crowd, to incite the riot, to advance Nazi theory. There's absolutely nothing in the record, which in the cases relied upon by the United States, those were factors where the court upheld using the offensive language as part of the sentence. Mr. Packer, there's nothing in the record to suggest any intent on his part. And the only reference in the record is that he was interviewed after he was arrested, and he was asked, "Why were you wearing that offensive T-shirt?" And his answer was, "Because it was cold out."
Are you taking the position that what you characterize as understandably characterized an offensive T-shirt, that offensive T-shirt can't be taken into account at all, period, for sentencing purposes?
I'm sorry.
Or are you taking the position that the district court didn't explain how it was taking it into account, and there may be some valid reasons to take it into account, but we don't know if it was for a valid reason or invalid reasons? Because part of what you're saying makes it sound like you're suggesting that fact can't be taken into account at all for sentencing, period.
Appreciate the court's question. If the T-shirt, if the offensive language on the T-shirt related to future dangerousness, then under precedent, yes, it could be taken into account. There's nothing here to suggest it could be used, could have been used for future dangerousness, because there was nothing in the record to support that. If the record showed that it was used to incite others to act in a certain way, then it could be used. So generally, there may be ways that it could have been relevant, but in this specific context, there was absolutely nothing in this record, nothing about the actions of Mr. Packer to support using that T-shirt in any way. And again, as Nichols says, he said he inferred some type of an intent from it. And that we would submit is violated Mr. First Amendment rights.
What if the sweatshirt said stop the count?
I'm sorry.
What if the sweatshirt said stop the count? Could that be could that be considered in sentencing?
It may have been, because that's what the purpose of the rally was. But this was.
That's still First Amendment speech.
But if it's used to incite action, and again, we need more facts to put it into context, it might be something that's useful. Another example I would use is we go back to Charlottesville in 2017, where the people are marching and they're chanting, "The Jews will not replace us."
Mm-hmm.
If he had been wearing a Camp Auschwitz T-shirt in that context, there may have been something that may have been a factor that a judge could have used at a sentencing hearing, but there's nothing in this record to come close to that, to support that. And again, the only reference is he said he was cold. So there's nothing to show that he himself is a Nazi sympathizer. There's nothing to suggest that he was promoting Nazi ideology or anything else. He's just wearing a T-shirt with offensive words on it, and would submit that's protectable.
Generally you would be providing the transcript under our appellate rules. Should we then on our own look at the transcript so that we can make an assessment?
Yes, certainly.
And can I just ask one more question about the sentencing, the appeal waiver? So just so I'm understanding your argument, I know that the appeal waiver provisions often have a carve out for sentences above the statutory maximum. So I'm not talking about a misapplication of the guidelines that would take you above the statutory maximum. I'm just saying that there's a guideline factor that is applied by the district court in a way that doesn't seem consistent with the guidelines. That there's a legal claim that factor actually shouldn't have been applied in the same way. It doesn't come into play. Are you saying that the appeal waiver doesn't cover that kind of claim too, in the same way that it doesn't cover the kind of claim that you're making now, or are you drawing a distinction with the type of claim you're making now?
I'm drawing a distinction because this is a violation of a constitutional right.
So you're saying constitutional claims are in a different category?
Well, yeah, in this category, yes, constitutional.
For waiver purposes, the way appeal waivers don't cover constitutional claims. That's your...
That would be our position, yes.
What is your particular relief that you ask for in this regard? Because he's already served a sentence.
Well, we would ask for resentencing, to remand the case for resentencing, and for Judge Nichols to provide further explanation for the reasons. And the only remaining collateral consequences defined for reasons that do not pertain to the T-shirt. And again, understand that this was agreed upon, but the judge doesn't have to follow that. Like in any agreed upon plea, trial judge 11C1C says you don't have to follow. Judges typically will, but they do make findings. But in this case, those findings were not made, and the judge could have.
Did he reference a sweatshirt at any time when he was discussing the amount of restitution ordered?
No, but he did.
You have the quotes about for the length of the sentence.
Yes.
But not for the restitution, which was agreed upon.
No, and he only briefly mentioned.
It was as low as he's ever gone before, anyhow.
That's correct. Well, yes, and he said that's as low as it's ever gone in the context of a fine.
Mm-hmm.
That position, it doesn't really matter, fine or restitution.
Right, you don't, whether it's called fine or restitution, it's the same for you.
In this context, yes.
Mm-hmm.
Make sure my colleagues don't have additional questions for you this time. We'll give you a little time for
Thank you
rebuttal.
very much.
Thank you. Counsel, Mr. Hobel.
May it please the court, Mark Hobel for the United States. This appeal should be dismissed as moot. Packer challenges only the length of his prison sentence. He's already served that sentence and he was released on December 30th. To the extent that he is now claiming there are continuing collateral consequences associated with the $500 restitution, that restitution, he agreed to pay it. It has nothing to do with the length of the sentence.
Did he raise restitution as a collateral consequence in his brief?
No, I don't believe he addressed restitution. I'm sorry, mootness at all in his brief, and he did not file a reply brief responding to our mootness arguments. I direct the court just to.
But he pretty clearly argued that he thought the length of the sentence imposed was impacted by the sweatshirt, impermissibly affected by the sweatshirt he was wearing, but he did not do that with respect to restitution.
That's correct, Your Honor. I just direct the court's attention to page 174 of the appendix, which is the district court statement that Packer agreed to pay the $500 restitution. I think the court may have just misspoken when it said.
But I'm not sure I follow the agreement part of it. You layered in two things. One is that there was an agreement, and the second is that the length of the sentence didn't vary based on it. Those two things don't necessarily go together. And if the agreement part of it, let's suppose restitution does turn on the length of the sentence. And the fact that he agrees to it as part of a plea agreement, would that mean that it doesn't get taken into account for mootness purposes? Because then if you could send it back and then the restitutionary award would potentially be different, even though he agreed to it.
That's right. I'm tempted to say I think he'd still have a high hurdle on mootness given the agreement. But the key factor here, Your Honor, is that the length of his prison sentence had nothing to do with his with the restitution. So the argument today that, you know, notionally, if the case was remanded for resentencing on the length of the sentence, that the restitution would alter is just completely speculative. Remand for a resentencing would be an empty exercise. And so, you know, we would urge this court to dismiss this as moot. Let me just quickly address his point about future sentencing and that his sentence might be enhanced in the future. The Supreme Court in Spencer v. Kemna has been was pretty clear on this, and we cited Spencer in our brief. A similar claim was likewise considered and rejected in Lane v. Williams because it was contingent upon respondents violating the law, getting caught, and being convicted. Respondents themselves are able and indeed required by law to prevent such a possibility from occurring. The speculative prospect that Packer might reoffend and be subject to additional sentencing, that's within his control. That's not sufficient to maintain standing where his release from prison has already mooted his challenge to the sentence.
Do you know if Virginia has sentencing guidelines or whatever its sentencing system is, if he were convicted again under Virginia law, which is what his criminal history is, whether that would factor in this sentence?
I don't, Your Honor. I apologize.
Because there's some argument there that he's not in control of his behavior when it comes to alcoholism. So it's not so much the choice making that you just referenced in Spencer.
Right. I would just direct, you know, I'm not familiar with Virginia law but I don't think it matters, Your Honor. As a legal matter, the prospect of having your sentence enhanced in a future proceeding, that's insufficient to maintain standing to a sentencing challenge.
Mm-hmm. And back to the restitution one more time. Sorry, I know you want to move on, but you said it's speculative, but the legal factors that courts consider in setting the amount of restitution, the facts and the legal principles that they consider, does length of sentence, at least for misdemeanors like this, factor in at all?
Your Honor, I have to apologize. I'm not sure I'm prepared to answer that, in part because I'm hearing for the first time today the restitution response to our mootness argument, because again, Packer did not file a reply brief. I note here that on this record, there is no connection between the length of the sentence that he received and the restitution he paid. The district court here carefully went through all the sentencing factors, considered the nature of his conduct, his background. The restitution, because he agreed to it, was sort of imposed at the end without much discussion. It wasn't part of the discussion of the factors.
And he had agreed in advance in the appeal, or sorry, in his plea agreement to the $500 for restitution.
You know, I unfortunately, off the top of my head, I don't remember. I think that's what Mr. Keir said earlier. But, you know, certainly at the time.
But hadn't agreed to the amount of sentence, the length of the sentence in the agreement.
He had not, but, you know, he did obviously appeal his right to, he did waive his right to appeal the sentence unless it was over the statutory maximum. Everybody's agreed here that the sentence he received is below the 6-month statutory maximum. So, you know, even if the court were not to, were to disagree with us on mootness, we'd ask this court to follow its ordinary course and enforce the appeal waiver. I know, Judge Childs, you'd asked about the plea transcript. We did not have that at the time that we filed our opposition brief, but we filed a copy of the plea transcript last week. And the district court did review the terms of the appeal waiver with Packer. Did accurately state you're waiving your right to appeal unless I give you a sentence above the statutory maximum, which did not occur here. So this is not a case like Kaufman, which Packer cited in his opening brief, in which the district court essentially rewrote the terms of the appeal waiver on the spot during the plea colloquy. The district court accurately repeated the terms of the plea of the appeal waiver and the plea agreement. Those terms should be honored here. And
So we do have decisions on appeal waivers that say that there are certain situations in which we won't enforce an appeal waiver. And one of them is when the sentencing court, what we said is rest a sentence on a constitutionally impermissible factor, such as the defendant's race or religion.
That's correct, Your Honor. The court did say that, and I believe the Gillen case, and we cited that in our brief. That did not occur here.
Isn't that his claim that the sentence it's based on a constitutionally impermissible factor?
That is his claim, Your Honor, and I'm happy to address it. That did not occur here. The sweatshirt was. He wore it during his participation in the mob.
That's on the merits of the claim, and I want to hear your argument on the merits. But I guess what I'm asking is in terms of the waiver. If that's a basis to not enforce a waiver, then the enforceability of the waiver doesn't turn on whether the claim is valid or not at the end of the day.
Right, and I think what it in effect does is it narrows the scope of the permissible claim he could bring. So, for instance, Chief Judge Srinivasan, you had asked Mr. Kirsch whether he was appealing whether the district court was, gave a sort of sufficiently detailed explanation for his reasons for relying on the sweatshirt in part. That type of claim would be barred by the appeal waiver, clearly going to sort of a procedural reasonableness of imposing the sentence and relying on that fact. So it does narrow the scope of the claim and again, to reach through the appeal waiver, to reach through mootness too, which we can't have done. But Mr. Packer really has to argue that the have to be a very blatant person in violation. That's not. I mean, Packer was wearing a shirt that said Camp Auschwitz, staff at Camp Auschwitz, applying identification with death camp guards. At the scene of the rally, to the extent that Packer is now arguing that a "Stop the Steal" sign would be something permissible to consider because it shows your purpose or intent in joining the riot. Certainly, Camp Auschwitz sweatshirt demonstrates or at least raises an inference of purpose for intent and motive for joining the riot.
How does it connect to this? I mean, he made the distinction between maybe the Charlottesville March and this one. So that's what I didn't see from the district court, and I'm not naturally getting is what is the connection?
Mm-hmm. So I like to quote, Your Honor, from the government sentencing allocution where we did draw this connection, pages 148 to 49 of the appendix. We stated, and Mr. Packer was everywhere that violence happened, except for the rotunda and the East Stores, Your Honor. He was everywhere else. He broadcast his intention for joining the riot. He wanted to support the subversion of our republic and keep a dictatorial ruler in place by force and violence. And his words on his clothing showed you his intent. I note too.
So his intent was?
In order to participating in the mob, the inference that the shirt raises is that in participating in the mob attack on the Capitol, he was seeking to participate in the violent overthrow of our democracy, our republic. He's not in his sentencing memorandum. He compared himself to Forrest Gump as sort of a passive, peaceful observer, and the shirt truly belies that characterization. Was highly relevant in sentencing. I note too, in addition to his purpose and motive. Which
right, so the point was this to connect to like a white supremacist desire to overthrow the government? Is that the connection between the Camp Auschwitz and I would get like the Stop the Steal or, stop government can't be trusted or something like that. But it requires a little more inferring or stretch here to get the connection, at least in my eyes, a disgusting and appalling sweatshirt. But we have to be really, really careful in this country about when First Amendment protected activities can be a basis for imprisonment. That's something very important in this country. And sometimes again, certainly if it really is right in the heart of the matter, let's take over the Capitol shirt would be perfectly relevant. But this one is you got to admit it's a few steps away from that.
No, and I want to be clear too that the government is being careful here and is being sensitive to these First Amendment concerns. I mean, I do think that when Mr. Keir said that the government really emphasized this shirt in our sentencing memo, that's just inaccurate. I mean, we did not foreground this shirt except to the extent that we said it was distinctive, which enables, and we included a number of pictures and screenshots from video to show Packer going to the Capitol. And we also noted that his answers to the FBI about why he was wearing it, he was cold, were his answers, that indicates that he was not completely forthcoming with the FBI during his debrief. And that does go to the extent of remorse. So we did not heavily emphasize this, despite what Mr. Keir says in our memorandum. But
Well, if it's relevant, then there's no reason not to emphasize it. That's what, so I'm not,
right.
I'm just trying to get the connection as to relevance, because this one seems to me harder to link up than a lot of other things one can imagine. And again, the First Amendment it's really, really important that we not imprison people for speech,
Well,
unless their speech is criminal.
Understood. I would argue that the inference does there is a clear inference linking a Camp Auschwitz sweatshirt, an SS T-shirt that's worn underneath the two white.
Nobody saw that.
Right. And I know too, there are other legitimate sentencing purposes here. That shirt conveys a threat. It's intimidating. It expresses essentially that this person, that Packer, sympathizes with the people who killed millions of Jews and others in the Holocaust. And it's also as to future dangerousness, and Mr. Kirsch even, I believe, acknowledged that. We cited to United States v. Schmidt, a recent Seventh Circuit case, in which, unlike in this case where there was a clear connection between the crime and the expression or the belief of Nazism, in Schmidt, it was a felon in possession case where there was not a connection between the crime, a clear connection between the crime and the Nazi beliefs, but the Seventh Circuit still upheld the district court's reliance on it based on the threat of future dangerousness.
In the Gilling case, it mentions a waiver does not shield from review a sentence colorably alleged to rest upon a constitutionally impermissible factor. So I want you to focus on the word colorably.
Right. We would disagree that Packer has raised a colorable First Amendment claim here. This is this is not a situation like the Lemon case, this court's precedent, in which there were no facts connecting. In that case, it was a check cashing case, a bad check cashing case, and there were no facts connecting the defendant's association with the Black Hebrews group and the crime. Here, there is a clear connection between the crime and the shirt. He was wearing the shirt during the crime, and the district court was permitted to draw reasonable inferences from that, and the First Amendment did not stand in the way of the district court considering. But in the end, I'd return to the mootness point. There is no effective remedy here. He's already served his sentence. We would ask this court to dismiss this case as moot and leave the district court's judgment in place. Unless there are any further questions.
Okay.
Thank you.
Thank you, Mr. Rebel. Mr. Kirsch, we'll give you 2 minutes for rebuttal.
Going back to United States versus Lemon, which is cited in our brief, this court, and Lemon's still good law, this court, and it's already been referenced by this panel, but this court very specifically said that a sentence based any degree on activities or beliefs protected by the First Amendment is constitutionally invalid. And we would submit that that is why this case should not be dismissed, and that is why this case clearly falls within Mr. Packer's statutory right to appeal, regardless of the fact that he said he wasn't going to appeal, but that acceptance was made before he knew that there was going to be an illegal sentence imposed. And then the government argues, and again, this court has to make the final determination, but the government continues to argue that there's no connection between the government argues there is a connection between the T-shirt and the crime. It's not correct. Sorry. There clearly is no, that I can see from the record, any connection between the crime and the T-shirt. There's no reference, there's nothing, there are no remarks by Mr. Packer. There's nothing from which this court can infer there's a connection, but Judge Nichols did make that inference. He said, I have to infer there's the nefarious intent. We submit that was improper. So for all those reasons, we would submit that this case is, that Mr. Packer did not waive, this case is not moot, and that his First Amendment rights were in fact. Thank you.
Thank you, counsel. Thank you to both counsel. Take this case under submission. Mr. Kirsch, you were appointed by the court to assist the appellant in this matter, and the court thanks you for your assistance.
Case number 22-5050 et al. Angela M. Cox, appellant, versus Kilolo Kijakazi, acting commissioner, Social Security Administration. Ms. Penna for the appellant, Ms. Klein for the appellate.
Good morning, counsel. Ms. Penna, please proceed when you're ready.
Good morning. May it please the court, I'm Tina Bena. I'm here today representing Ms. Angela Cox, who is in the courtroom today. I wanted to make clear a particular point. Listings are special at the Social Security Administration. They are automatic if they are objective, as was listing 1205C for intellectual disability. There's no discretion. The administrative law judge, the other adjudicating officers at the state agency, the doctors, have no discretion. And that matters because under the regulations, 20 CFR 416-501, 416-920 A and T, there is a regulatory guarantee. We will find you disabled if you meet a list and file an application, and of course meet the eligibility requirements, the eligibility requirements of income and resources or insurance company. Either way. It's also consistent with the Supreme Court's ruling in Bowen v. Young. Ms. Cox met a list. She filed an application and she was denied. It's a first level of adjudication in front of the doctor. They neglected their duty. They had in front of them the opinion of a consultative examiner that she was disabled, not just that had deficits, she was disabled. They ignored that. They ignored the findings of the IQ test, valid IQ testing, and simply made her wait for years until the agency changed its rule. The agency has no retroactive rulemaking authority. That's quite clear. But nonetheless, it applied. It revised its middle listings, and it applied those to pending cases, court remand cases, and continuing disability review cases.
Can I
They
ask you,
violated the APA. They did not put any of that out for notice and comment. None of it.
can I ask you, there's a statutory definition of disability, which the agency obviously cannot depart.
I'm sorry.
There's a statutory definition of disability that the agency obviously is bound by. The claimant is considered disabled if she is unable to participate in any substantial gainful activity due to a medically determinable physical or mental impairment. And you don't dispute that that's the governing standard of disability.
Yes, Your Honor. The listings are there.
No, I'm just saying, but you
In order
accept that you accept that that's the controlling definition of disability that everybody has to meet. And the listings had been a prior way of meeting that.
Yes, that they are an official statement of levels of medical severity, if you will.
But everyone still has to meet the statutory
That
standard.
they
That was a means of doing so.
They are a presumption that, and they are a binding presumption, that that individual cannot work. I can give you
I'm just trying to understand your legal position. So your legal position is you accept that that is the definition of disability that necessarily bound the agency because it was passed by Congress.
right.
That's the statute. And you're not claiming that someone who doesn't meet the statutory definition of disability should still get benefits. Are you?
No.
No. So right. So at bottom, everyone has to be found to meet that statutory definition of disability. I'm just trying to understand your position. And your position is that listings or sort of an agency sort of predetermination that if you meet this, one of these criteria, you will necessarily meet the statutory definition.
Exactly so.
But your clients still must at bottom, one way or the other,
Exactly
meet
so.
the statutory
And that's why the
definition.
regulation is there that stating that presumption, we will find you disabled.
So as long as she can still show that she meets the statutory definition of disability, she will get
You're automatic. That
with or
don't
without.
go into work at
People
all.
meet it without, there's other ways there, right? Some people meet it without going through the listings and they still, as long as they show that they meet the statutory definition of disability, they get the benefits.
The listings are the presumption.
I understand, but some people don't fall within the listings, I assume. And so, but they still can show that they meet the statutory definition of disability by going through the other factors.
If they do not meet a listing, then yes, they proceed through the process and appear before an administrator.
So everybody at the
Administrative
end
law
has to meet
judge
the statutory
who does
definition.
the sequential evaluation process and makes the determination that given the symptoms of the various impairments, this person cannot work. In this case, of course, the administrative law judge mischaracterized the evidence. So his final determination was it. But yes, that's it.
No, so your point is, even with or without listings, she meets the definition, and to the extent the ALJ found otherwise here, it was because of error.
If you meet a listing, you are disabled.
No, my question is a little different than that. My question is, your argument, as I understand it, is she should be disqualified on two grounds. She met the listing, and even if you put the listings aside, she came in with the evidence that shows she meets the statutory definition of disability. Yeah. Okay. And so it's just a question of how one goes about proving that you meet the statutory definition of disability. Listing or evidence. Separate additional evidence or separate evidence. There's two paths.
There are two ways to meet the statutory definition. This listing or an ALJ decision.
Right. And so they left, she still had the opportunity, even under the new regulations, to show that she met the statutory definition. That's why you have the arguments about the mistakes that the ALJ made. Right?
In theory, yes, ma'am.
In theory, in reality, you have arguments that the ALJ also misweighed evidence and things like that.
ALJ who did not. And so I'm having some difficulty agreeing that the opportunity, you have a theoretical opportunity, of course, hypothetical. But we have an ALJ here who disregarded, the listing disregarded this court's precedents in Butler. So that's my difficulty with agreeing.
No, I'm just asking, your position
that
is
it's
she would,
hypothetical.
I'm only asking about your position is that she would meet it either way,
Of course.
listing or evidence.
Yeah.
Without the listing, with evidence, she would meet it. And so the question is,
Right. Right.
the reason
I
that
agree.
here was just errors by the ALJ.
Yeah.
Is your argument.
And then talk to me about please, the notice and comment period. It was 105 days. There were, several comments in that regard, but you're suggesting that there wasn't really notice and such that there couldn't be a logical
I'm having
outgrowth.
difficulty hearing you.
The notice and comment period was 105 days, several comments that came out, but you're suggesting that there wasn't sufficient notice such that there could be a logical outgrowth of this rule.
I'm still having trouble hearing you, Your Honor.
I'm asking you about your position with respect to notice, with respect to this new listing rule. There was a 105-day comment period and several comments made, but you still suggest that this rule would not be a logical outcome.
We do not know who made those comments. They could have come from within the agency. So that's problem number one from my perspective. However, the fact that somebody figured it out, actually they did, somebody made a different suggestion to the agency that the agency had not heretofore proposed. In fact, they proposed the opposite. And I believe the precedents in Alina make it clear that when an agency specifically proposes, as they did here, to keep a regulation, they cannot simply reverse. Here, they did not put that proposition out for notice of comment. It depended entirely on the possibility that somebody might notice. Somebody did. But that does not allow the agency to escape its notice and opportunity for comment obligations. Secondly, the final rule contains no explanation, no reason explanation. It does not address how they considered various, or even if they did, consider various alternatives. And that's only with respect to listing 1205C. The agency never mentioned that they were taking away the right of this individual to rely on her plausible, uncontradicted testimony. Nowhere is that mentioned. They never mentioned taking away the presumption, clinical presumption, that is still used, clinical presumption that IQ levels are stable over a lifetime, barring evidence to the contrary, actual evidence to the contrary.
Make sure there's no additional questions for you at this time. We'll give you a little bit of time for rebuttal, and we'll hear from the government. Ms. Klein?
May it please the court, Elisa Klein for the Social Security Administration. I'll be brief and I want to address the court's questions. Judge Millett, yes, as the Supreme Court in the Yuckert case that we cite emphasized, listings are not comprehensive, and anyone who is not found disabled by virtue of meeting a listing, the inquiry at each stage of the adjudication, whether it's the state level stage or the ALJ stage, then just proceeds to residual functional capacity and the vocational factors, steps 4 and 5. And of course, the agency could not change the statutory standard that determines whether or not benefits will be awarded. This, again, very briefly, as Judge Nichols and Judge Easterbrook explained, the agency's longstanding policy is to instruct its adjudicators at every level to use the most up-to-date listings. These are the most up-to-date medical standards when they're adjudicating an application for benefits. And that's a permissible policy under the broad discretion that Congress gave to the administration to basically oversee this gigantic apparatus of processing applications for benefits. And it is not retroactive in the land graph sense for the reasons that were set out by Judge Nichols and in our brief.
You don't dispute that, or do you dispute that had the listings been applied, that she would have been entitled to benefits?
We do dispute that. We've assumed, we're not asking this court to decide that, but there's a chart in our district court brief on page 7 that sets out side by side the central requirements under the prior listing 1205 and under the 2017 version. And as we explained in our brief, it was always a requirement to show deficits in adaptive functioning. That requirement—
Even as part of the listings?
Yes, as part of listing 1205. So same, the name was different. Intellectual disorder at the time was called mental retardation and the name got changed. But the substantive showing of deficits in adaptive functioning was present under the—
So even if she met the sort of IQ range,
yes,
that would not automatically get her benefits?
Exactly. And I'm not suggesting there was no change. There's more specificity in the 2017 version of that listing 12.05 that talks about the severity and has some more detail. But our point, and again, we're not asking this court to decide it. We're just making the point that the administrative law judge went through and found, addressed each of the areas of deficits in adaptive functioning and made findings with respect to those. So while we are assuming for purposes of the retroactivity analysis that this change made a difference, we're not conceding. But again,
so if we assume that, though, at least in National Mining Congress, we had language that said where a rule changes the law in a way that adversely affects the party's prospects for success on the merits of the claim, it may operate retroactively. So if you're assuming for purposes of this case that it definitely changed for success on the merits, not just her prospects, but actual success on the merits, how is that standard not met?
Because that language from National Mining, which is what the district court relied on in this case, has to be understood in the context of the statute, the particular program that was at issue there. This court did not and could not change this court's prior decisions in Chadmore and the line that we cite in our brief that said an applicant for government benefits has no vested right while the application is pending. And that's just a general principle also referenced by Judge Easterbrook in the McCabe case. National Mining was different, potentially unique, because the benefits were being paid by the employer. So the whole issue in the case was, could the Department of Labor apply, I'm using retroactive in a colloquial sense, retroactively apply new rules in a way that increased the liability of the employers, the coal mine operators and their insurance companies. So if you look back at the briefing, the whole fighting, there was no dispute that that would have implicated land graph, and the fighting was over whether there were or were not material changes to the regulations. But you can't take that language and pull it out of the unusual context in which the benefits at issue were payable by the private employer.
That's a question about the treating physician part of the challenge. So under the regulations, they presuppose that the treating physician's opinion can have greater weight than somebody else. And I just didn't see anything in the ALJ's treatment of the treating physician that A, acknowledged that it was a treating physician, and then B, wrestled with whether, because it's the treating physician, I guess it was Hawthorne, whether Dr. Hawthorne was the treating physician, notwithstanding the fact of treating physician status, there still was going to be a discount of those views for the reasons that were set out.
All right. So I took it as implicit that the ALJ understood that Colleen Hawthorne was the treating physician, because the ALJ then did go through and explain why she was being given partial weight rather than greater weight as would be expected of a treating physician. And the ALJ
Wasn't there similar language about other opinions too? The partial weight went to other physicians too. It just didn't seem like there was a distinction based on treating physicians.
Since I don't believe this was the focus of the appeal, and I don't recall the specifics, but as we understood it, yes, of course, the ALJ knew this was a treating physician, but said that this was, with respect to Hawthorne herself, there were contradictions in her own, I don't remember if it was testimony in medical records, in addition to contradictions with other physicians, and other evidence. But again, we would not be here if the only issue were the treating physician. So I want to make sure the court is satisfied as to retroactivity, which is why we appealed. And I also just want to make sure I address, Judge Childs, your question about logical outgrowth. And to just go back to this chart, the changes to this listing, they're certainly important. It is important to align the listings with the up-to-date, categories that are used by the American Psychological Association, the outside experts. And those experts, their own treatment then informs what the clinical records look like. So this is important, but the changes were still comparatively modest. And what happened was, after the agency made various reorganization to this particular listing, 12.05, comments came in and said, paragraph C is now unnecessary. And you should streamline this listing, to avoid complicating the process for the adjudicator. And that's why, it's certainly a logical outgrowth if the agency takes into account the fact that commentators who are being asked, to comment on what do you think of this proposal, say, do this thing to simplify the work of the adjudicators, that it's reasonable.
Well, it's not a logical outgrowth of a notice that says we will not change 1205C except for minor editorial adjustments. It's language to that effect is what was used. We will not be changing it. And you are assuming for purposes of this argument, so I assume you're assuming it for purposes of the whole argument, that she would have won under this provision that's now been eliminated. That doesn't seem at all like a logical outgrowth of a we're not changing it. And it seems like a profoundly substantive change from the perspective of the claimants.
The premise is very wrong. Obviously, there was no statement, we will not change paragraph C, but also, again,
it was only minor editorial.
No, but this is going back to the other point. I think that the plaintiff is missing that all along there was a requirement to show deficits in adaptive functioning. Things got moved around, and there was more specificity as to that showing, but that was always going to be a required showing, even if you applied the old version of the listing.
But it wouldn't be enough under the new. If you have you may need deficits in adaptive functioning, but that wouldn't get you all the way home under the listings, right? Because you still have to show more.
As before, you had to show, the IQ testing. That's not a change.
No, but I'm taking that as a given too. So the IQ range plus deficits of adaptive functioning under the new provision, there's still, you have to show extreme limitation of one or marked limitation of two of the following areas of mental functioning, and then the list A, B, C, or D.
Yeah, to be clear, those are the deficits in adaptive functioning. The terminology has changed, and it is more specific. It's, to describe the level of severity, it had to be extreme in one or moderate in two. But this is all just deficits in adaptive functioning. I just want to make sure that the court understands, because I know it's complicated, that this was in many ways a reorganization that made C unnecessary.
But I thought we're taking as a given that the change, I know there was some reorganization and some encapsulation, but I thought we're taking as a given that there's a delta between what existed pre-20, whatever year it is, the 2017 listings, and now. And there were things that would have automatically qualified you as disabled under the listings previously that wouldn't necessarily get you all the way home now.
Yes, with the pause on automatically, there had to be a showing of deficits in adaptive functioning. And that's why, in response to her argument that there should be a remand for an award of benefits, we've said no. The ALJ addressed deficits in adaptive functioning and said,
Right. I mean, we may not remand to get to automatically give benefits, but just in terms of whether somebody's worse off. I thought we're taking it as a
Yes.
given that somebody could be worse off under the new listings than the old ones. They might still be able to satisfy steps 4, and 5, even if they don't automatically get in under the listings. I get that. But in terms of automatically getting in under the listings, somebody could be worse off under the new approach than the previous one.
yes, we're taking that as a given. It is, of course, also true that in general, there's nothing systematic about updating the medical listings that disadvantages claimants as a class. And so there may well be many claimants who say, wait, you added a listing, you should be adjudicating my application with the benefit. And then just finally, the broad
But
point.
just to be clear, someone prior to 2017, if they showed that they met for one of the listings, sort of the IQ range plus deficits in adaptive functioning, they showed both of those, go directly to benefits, right? Automatically we get benefits.
There was another category. It's in the chart. It's an additional impairment that affects the ability to work.
Right, and they also have to show it was before 20 or 22 or whatever that was. But so they do that. And then now someone can make that exact same showing. They wouldn't get benefits automatically. They still have to go through steps 4 and 5, or at least step 5.
We're assuming that the additional specificity for the deficits in adaptive functioning category may actually make a difference for someone.
Yeah.
We're not
Because
assuming,
they still have to go through steps 4 and 5,
yes, we're assuming
particularly
that.
the vocational step 5.
And then you go through steps 4 and 5 and can show that I nonetheless meet the statutory.
Right, but there's a group of people, in theory, at least a group of people who would have qualified before, who
We are,
will no longer qualify.
right, like the other courts, we are assuming, for purposes of this appeal, yes, that could happen. But we're also making the more general point that there's nothing about updating medical listings that systematically disadvantages claimants. And the final point, if I may, is that as the Supreme Court, repeatedly admonished, this is a gigantic and very complicated adjudicatory system. And so efficiency, maybe in some contexts, doesn't matter very much. But for the Social Security Administration, keeping things simple and fast for the adjudicators is very important because of how long people wait to get a decision, even at the first level, on their applications for benefits. So the recent statistics were 5.5 months at that first level, where a very large percentage are granted. So this is part of the reason the Supreme Court has consistently emphasized that the Social Security Administration, by statute, has really broad discretion to figure out the mechanisms, the procedures by which its adjudicators determine whether someone meets the statutory
But
requirement.
you don't argue that any different retroactivity analysis applies in this context, do you? Because it's actually really hard to figure out how to do it for exactly the reason you said. The same change can help someone and hurt someone else. And so how do we decide, sort of under a land graph type analysis, whether...
So the land graph analysis here should be straightforward for the reasons Judge Nichols set out. We're not increasing liability for anyone. We're not attaching new adverse consequences to primary conduct that happened in the past. And so the only issue is the one Judge Nichols walked through about vested rights. And under this court's decision in Chadmore and the case it cites, there is no vested right when you just have an application for government benefits.
Look at the consequences of having performed some work before change.
No, so I'm glad the court asked this question, because this is where the distinction between Social Security disability insurance and SSI is potentially relevant, but I want to explain why it shouldn't be. So this case is Social Security, SSI. This is, sort of the pure welfare program that was added in the 70s. The Supreme Court, though, cautioned in Fleming versus Nestor, and in a way in Matthews versus Eldridge, that even when you're talking about the category of workers who paid into the system and for that reason became entitled to either retirement benefits was Fleming versus Nestor, or disability insurance benefits was Matthews versus Eldridge, the court still cautioned about not importing, at least at a constitutional level, these accrued property rights notions. That's when the Supreme Court said this would freeze up a system that depends upon flexibility in a way that was not intended. So the issue is not before the court here, but I just want to caution that the court should not accidentally suggest that there's nothing the Social Security Administration could do to streamline what are called its continuing disability reviews that it's required to do by statute, which is once someone is a recipient, it's been found entitled, there's nonetheless a periodic, could be 5-year, 7-year, shorter inquiry into whether that person should still be getting benefits. And I'm just
Is there anything the Social Security Administration could do with respect to changing the listings that would be retroactive?
the Social Security Administration's policy is that at that continuing disability stage review, changes in the listings are not considered. So there's nothing, barring a hypothetical change to that policy that could be done to the listings that would be retroactive.
So no matter how much the listings changed,
Correct, because the listings
couldn't be retroactive.
And to put it the way the Supreme Court put it is, this is for initial applicants. It's a way of streamlining the adjudicators.
Right. So to cut to the chase, there's nothing you could do, no matter how much more restrictive the listings got in terms of automatically qualifying as disabled without having to go through steps 4 and 5. It definitionally can't be retroactive.
Correct.
And just to understand, I want to follow up on Judge Millett's question. So as I understand the assumptions on which we're resolving this case, it has nothing to do with steps 4 and 5, because under step 3, the assumption on which we're considering the case is that pre-2017, someone might have qualified as disabled. Post-2017, that same person won't automatically qualify as disabled for step 3. They might still qualify as disabled under step 4 and 5, but they're worse off in a way that could be outcome determinative, because if they don't qualify under 4 and 5, they would have qualified pre-17 under step 3. Post-2017, they don't qualify.
Yeah, those are the assumptions.
Those are the assumptions, and
Judge Nichols' decision. Yeah.
And your argument is
That's not retroactive.
It can't be retroactive because it's just the automatic qualification under the listings, and definitionally that can never be retroactive.
Correct. Thank you.
Thank you, counsel. And I will give you 2 minutes for rebuttal.
Okay. Streamlining has absolutely nothing to do with depriving my client of her right to make her prima facie case on her uncontradicted plausible testimony. That is guaranteed by Goldberg v. Kelly. She had a right the minute she filed that application, and her IQ scores were confirmed. She had a right to her finding of disability. They made her wait. People wait, but they don't wait because they don't get decisions they were supposed to get a lot of the time. This regulations guarantee if your impairment meets the listing, you are disabled, and we will make that finding, and they did not. The notice and comment, there are no explanations. There's no reason for taking away her right to plausible uncontradicted testimony. There's no reason for taking away the presumption of IQ. None of that was ever discussed by the agency. This was not had nothing to do with streamlining. This had to do with cutting the budget. That's what it is. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 22-5137, Federal Trade Commission appellants versus Endo Pharmaceuticals, Inc. et al. Mr. Hegedus for the appellants, Mr. Gordon for the appellees Endo Pharmaceuticals et al., Mr. Lefkowitz for the appellees Impax Laboratories LLC et al.
Morning, counsel. Mr. Hegedus, please proceed when you're ready.
Good morning, Your Honors. May it please the court, Mark Hegedus for the Federal Trade Commission. When a company with a pre-existing right to compete agrees with a competitor to eliminate competition between them, that agreement could be subject to antitrust scrutiny. The FTC's complaint charges that Endo and Impax entered into that kind of an agreement. In 2017, the companies decided that rather than both selling Opana ER, they would agree that Endo would exit the market, stay off the market, and they would share the resulting monopoly profits. That agreement harmed competition and it harmed consumers. And the FTC should have the opportunity to show that that agreement violated the antitrust laws. The district court should not have dismissed the FTC's complaint for two basic reasons. First, the court was wrong to conclude that the agreement was simply an exercise of Endo's patent rights. The complaint plausibly alleged that Impax already had a broad, risk-free, non-exclusive license. Under the guise of an exclusive license, however, Impax purchased an unlawful monopoly. Second, the district court wrongly concluded that the FTC did not state an antitrust claim because the Patent Act permits patentees to grant exclusive licenses. But the Supreme Court has made clear that patent settlement agreements are subject to rule of reason review, just like other restraints of trade. And the FTC should be permitted to show that the 2017 agreement is unreasonable under the rule of reason.
Can I ask you just an upfront question, and that is, your complaint charged Impax alone with violating Section 2 of the Sherman Act. But your arguments to us have not distinguished between Impax and Endo. So for purposes of your appeal here, there's no difference between the two of them?
The complaint charges that Impax and Endo violated Section 1.
Correct, but only Impax on Section 2.
In terms of the unlawful monopolization, Section 2, it runs just to Impax, because Impax is the one who enjoys the monopoly as a result of the agreement. And the agreement itself is the exclusionary conduct that we allege that violates Section 2. But you're correct, Your Honor. Count 1, the Section 1 count is against both Endo and Impax, but the Section 2 count is against Impax alone.
Yeah, as your brief here hadn't broken out the second sort of distinct liability for alleged liability, to be clear, for Impax. But I take it your theory is because that just grows out naturally from if the Section 1 claim goes forward, then the fact that Impax would be the one receiving the monopoly, i.e. having the Section 2 claim, would come from that. So that's why you didn't break them out separately here?
That is correct, Your Honor. The exclusionary conduct on which we rely is the agreement itself. If we're unable to prove that that agreement is a violation of the antitrust laws, is anti-competitive, then we can't proceed with our Section 2 claim because that agreement is the exclusionary conduct that is one of the requirements for a Section 2 claim.
I just want to make sure about that. Okay.
Yes.
I'm sure I
yes.
understood that right.
So with respect to Impact's ability to be on the market, the 2010 license gave Impacts this broad, non-exclusive right to compete license, and it was royalty-free, and Impacts was on the market. That allegation of the complaint stems right from the license itself. It also reflects the party's characterization of that license made in two separate federal proceedings. In those one proceeding in the Northern District of Illinois, Endo told that court that the agreement was a right to compete agreement, which allowed Impacts to be on the market risk-free. Before the Federal Trade Commission, Impacts represented that this agreement was broad, it's a broad license, and it allowed Impacts to be on the market. Both of those representations were in fact made after Endo filed its suit against Impacts in 2016.
That was no doubt Impact's position in the litigation, including the 2016 litigation. But it was disputed, at least at that point in time, by Endo. And so, and Endo, survived a motion to dismiss, and Impacts is facing treble damages, which would be crippling to anybody. That's the point of treble damages. And so there was, its right to stay on the market was in question. What is suspicious? What can we as a matter of law say would allow an inference of anti-competitive conduct for the two of them to resolve that disagreement and to do so in a way that actually gives Impact something it didn't have before, and that is an exclusive license and a non-compete agreement from Endo?
Your Honor, there are several parts to my response to that question. The first is that it was inappropriate to resolve that dispute as part of the ruling on the motion to dismiss. And the district court effectively bought Endo and Impact's version of the dispute between us. And it was our complaint, and the complaint should have been given, the allegations of the complaint should have been construed in our favor. But secondly, when you
Can I just make sure, I do want to hear you, Liz. I'm so sorry to interrupt, but I'm not sure I even understand point one. It was improper for them to settle after the motion to dismiss? They couldn't settle after the motion to dismiss?
No,
I'm sure I misheard you, I'm sure.
And I'm sorry if I suggested that it was improper for them to settle after the motion to dismiss, but rather the fact of that dispute does not provide a basis to not accept as plausible the allegations in our complaint. And so the motion to dismiss, in our case, should have been decided based upon the allegations in the complaint, not based upon the fact that there was this legal dispute between Endo and Impacts. Now, with respect to that case, we also plausibly alleged that the Endo suit did not seek to take Impacts out of the market. The suit was about the appropriate royalty. You can examine the complaint itself, and it's all about the royalty. There's no indication that Endo was trying to take Impacts off the market. In addition, Endo did not seek to enjoin Impact from making those sales when it filed that suit. And even if Endo had succeeded in that suit, the chances of it succeeding in taking Impacts off the market were low, or would have been a difficult case for Endo to make, because it would have to have shown that it was irreparably harmed if it had to meet the standards for the traditional standards for an injunction. And that comes from the Supreme Court's decision in eBay. So the hurdles to Endo being able to take impacts off the market were substantial, which supports why it was that the court should not have credited the existence of that dispute as grounds to not accept as true core allegations that the complaint plausibly alleged that impacts had a right to be on the market. And that's an important allegation because it goes to the anti-competitive effects of this agreement. This was an agreement between competitors. They agreed that one of them would not compete and they would share monopoly profits.
Does that, why, couldn't you always say that whenever there's a patentee that enters into an agreement with a licensee to license the patent, they're potentially competitive, and the patentee can grant a license to the licensee in exchange for royalty payments? That's just garden variety stuff that happens all the time, as I understand it, in the patent sphere.
Your Honor, it does happen all the time in the patent sphere, although many of those agreements are between patentees and licensees who are not competitors. They stand in a vertical relationship where for some reason the patentee determines.
Well, let's suppose it's not. Let's suppose it's not what you're characterizing as a vertical arrangement. Let's just suppose it's just a situation in which there's a manufacturer of a product and then there's somebody who could make a generic. And I think those are horizontal. And then there's just an agreement. The manufacturer of the product who holds the patent just enters into an agreement with the producer of the potential producer of the generic and just says, look, we'll license you the patent. And in exchange for that, pay us a royalty. And it's an exclusive license. Let's just make it even more exclusive than this is. It's as exclusive as it can be. We're not going to get into this space. We're giving it to you, but you're going to pay us a royalty. That just seems like that's standard fare.
Your Honor, that is not standard fare.
It's not, okay.
That in a way describes a possible alternative agreement that could have been entered into the activist case itself. And I see, Your Honor, that I'm beyond my initial 10 minutes. I reserve 5 minutes for rebuttal, so I just want to acknowledge that.
We'll give you some rebuttal time, but you should keep answering questions as long as we ask them.
Okay. Yes,
yeah,
Your
thank
Honor.
you. Thank you.
I just wanted to acknowledge my time limit.
Of course.
Suppose an activist, rather than the generic agreeing to stay out of the market for a share of the brand's monopoly profits, the agreement had been that the generic would enter the market, the brand would exit, the generic would pay a portion of it, split the royalties, split its revenues with the brand as a royalty. That agreement is anti-competitive in the same way that the agreement in the actual activist case is anti-competitive. You have two competitors coming together, agreeing that only one of them will compete, and then they will share the resulting monopoly profits.
So does that?
I thought.
You go ahead. You probably have the same question.
I thought the patent statute just allows the patent holder to grant a license. Isn't that the patent? Isn't that a basic part and parcel of having the patent? Is that you can license it and exclusively license it? And I take it that this is how an exclusive license works: is that you grant an exclusive license in exchange for granting the exclusive license, you get something. And one thing that seems readily conceivable that you would get is a payment of a royalty.
It does allow that, but activist holds, as did a long series of cases that preceded activists, that kind of agreement, if it has anti-competitive effect, should at least be examined under the antitrust laws. And that's all we're asking.
But I thought activists thought that, at least in part because of what it viewed to be the peculiarities of a reverse payment arrangement. But what I'm hypothesizing, I think, doesn't fit within that description. It's just the standard situation in which a patent holder grants a license and make it an exclusive license to make it as anti-competitive as possible in the way that I think you're perceiving the world. And in exchange for granting the exclusive license, the licensee pays a royalty.
Economically, Your Honor, the situation, your hypothetical, and the situation activists are the same in that competitors, where there's some doubt about one of them to be on the market, agrees that one of them will stay off the market and they will share the resulting monopoly profits. So whether that is achieved by the brand staying on the market and then paying the generic to stay off the market, or the generic coming onto the market and the brand coming off the market for a share of the royalties, the economic effect is the same.
So I'm sorry.
Oh, please.
So under your position, going forward, no patentee could undertake, say in 2010, they had taken what they did in 2010, 2017, just did it all in 2010. They agreed to an exclusive license, non-compete agreement, exclusive license, and compensation for royalties in 2010. They just did it all at once. That they and no other patent holder in this country who does an exclusive licensing agreement with a competitor, potential competitor, is in the pharmaceutical area, right? With a brand and a generic. Those can never be assumed going forward to be within the patent power. Because just to throw on the table, an activist, part of what the court was concerned about was, the weirdness of the patent holder sort of paying off and paying the competitor, and that there was concern that suggested the fragility or concerns about the patent and whether it would fail the invalidity challenge, which you don't have here. This patent has survived invalidity challenges right and left. So you've got a good, strong patent here. And so just assume in 2010, they had made an exclusive licensing agreement in 2010, one fell swoop, non-compete agreement, exclusive license, but strong patent. We know it's a strong patent. And royalty payments. They couldn't assume going forward that would be okay. Every one of those agreements is going to have to be subject to rule of reason analysis.
Your Honor, it is potentially subject to the rule of reason analysis, but there are several responses to the hypothetical you posed. I'm assuming that in that initial 2010 agreement that the two parties, in fact, were competitors or potential competitors.
We're only potential in the sense that it's happened here, but this goes on. Activist was pharmaceuticals too, and that is using Hatch-Waxman. The generic says, I want to come on the market. I'm the first filer. I want to come on the market, get my 180-day period of generic exclusivity. And to do that, I have to file this form that essentially says, I think your patent's invalid. So it's the sort of statutory thing. So that, yes, they're certainly definitely competitors.
Right.
Potential competitors.
Yes, Your Honor. And that relationship really does make a difference in the antitrust analysis. But more fundamentally, the rule under activists, which itself is based upon a long series of cases, is that the mere possession of a patent or the mere exercise of the patent rights does not immunize an agreement from antitrust scrutiny. Now, it may be that many agreements are not a problem under the antitrust laws because perhaps the patent itself does not give the patentee market power in an economic sense. So the patent does not give the patentee monopoly power in the economic sense. It only gives it monopoly over the patented product. Another issue is the competitive effects analysis itself, which is very important. So there are many agreements that would escape antitrust scrutiny, and that's really the ordinary exclusive licensing situation that's been posited here by a number of your honors. But what is different?
Just to be clear, had they done in 2010 what they accomplished if you combine 2010 and 2017, if they had just done the exclusive instead of doing a licensing agreement, but it wasn't exclusive until 2017. But if in 2010 instead they had just done the exclusive licensing agreement up front, it'd be no better off. We'd be here in the same challenges.
If we could make a case that impacts in that situation, the generic in that situation, was a legitimate competitor on the market.
Potential competitor.
Right. In that case, that agreement would be subject to antitrust scrutiny. It certainly would not enjoy immunity under the.
How would it be any different? I'm sorry.
No, please.
How would it be any different? How would your claims be any different under my hypothetical where you just upfront do an exclusive licensing agreement than what you have here? Would it be the same?
Economically, it would be the same.
I don't mean economically. Legally, would it be the same? They'd be in the same legal boat.
Yes, Your Honor. Yes, Your Honor. Antitrust is guided by economic realities. And in both the hypothetical agreement where Impacts is the monopolist, is the only one on the market, or Impacts at the outset, or this agreement where it happened after Impacts had been on the market and had a right to be on the market pursuant to the 2010 agreement. You have.
So the fact that's important to me what you just said. So the fact that they were already on the market by 2017, which you talked about a lot in your brief, actually doesn't matter for your antitrust theory. All that matters is that Endo gave Impacts and at the end of the day, we add it all up, Endo gave Impacts an exclusive licensing agreement. Endo said, and a non-compete, right? Endo's out. That's all that matters. And then that can always be challenged. Maybe you'll win, maybe you'll lose, but that can always be challenged under the rule of reason analysis because of it creates monopoly.
Yes, Your Honor, because they are in a horizontal relationship.
Yes, I'm surprised because I thought that your theory, and I'm not saying that necessarily that this theory would necessarily work. I'm not saying it doesn't work either, but I thought your theory was bottomed in the existence of the 2010 agreement as the predicate, and the 2017 agreement only becomes problematic by virtue of the 2010 agreement. But it sounds like your view based on your answers to Judge Millett's questions and the questions that I was posing earlier is that actually 2010 turns out not to matter because all that matters is that at the end of the day, there was the grant by one patent holder to a potential competitor of an exclusive license. And once you have the grant of an exclusive license, then what that does is it reduces the field of competition because these two entities could be in competition. Now it turns out only one of them is going to be producing. That creates anti-competitive consequences because prices can potentially go up, which of course they can whenever there's a monopoly, and that's anti-competitive. So it sounds like it doesn't matter that this happened in two steps, because if it all happened in one step, it would be and I think there's something to that it would be economically the same thing. And that was going to raise some questions about why should we draw a distinction if it goes between two steps, goes sequentially one step to two, or if it just collapses into one. But it sounds like you're now just saying, actually, it doesn't matter that it happened sequentially. What matters is that at the end of the day, there's the grant of an exclusive license, and that's subject to rule of reason scrutiny, period, after activists.
Yes, Your Honor, there is an important difference just in terms of how it is that Impacts is a competitor in the two circumstances. In the original 2010, or their dispute that led to the 2010 license, Impacts was threatening Endo's patents. There was a patent challenge to the validity of those patents. And so those were the relevant facts as to why Impacts was a competitor. In 2017, Impacts is on the market because it received this license in 2010. And it's important to bear in mind that what a license is. A license.
Then this line of reasoning, as I understand it, is predicated on what Impacts got in 2010. Maybe I've missed this whole exchange, but I thought in response to the questions that we're posing to you, theoretically, it doesn't matter that Impacts got anything in 2010. All that matters economically and legally under the antitrust laws after activists is that a monopolist patent holder granted an exclusive license to a potential competitor. Once you have that, that's subject to antitrust scrutiny after activists. And if that's true, then what you are starting to say and what I thought your brief focused on and your complaint is predicated on actually doesn't matter, because the 2010 agreement, everything that happened in 2017 could happen all the time between a patent holder and the producer of a generic who wants a license to make the generic. And you're saying that that gives rise to antitrust scrutiny under the rule of reason. That arrangement just gives rise to it because it's anti-competitive in that it's a monopolist patent holder who's granting an exclusive license to a potential competitor. That reduces the field of competition, ergo rule of reason scrutiny.
Yes, Your Honor. How we get to that position, you could have had the hypothetical that the parties entered into this agreement from the get-go.
Yeah.
That would be an antitrust problem.
And the same antitrust problem.
Right.
It would be the same one as if 2010 never happened.
Right. The facts of how they got there are relevant in terms of understanding the purpose of this agreement. So I'm not saying that the facts are irrelevant. We do need to consider them as part of the rule of reason analysis. But at the end of the day, the economic effect is you have two competitors deciding that one of them will not compete and they will share the monopoly profits. And they do that in settlement of a dispute.
So when a patent holder, the patent holder has a monopoly, right? The patent, I think it's just taken as a given that a patent gives a monopoly.
Over the patented product, Your Honor.
Right.
So at the time this agreement was entered into, the 2017 agreement, the patent, Endo's patent, could not exclude impact. A patent is a right to exclude. So, but by giving the agreement, the 2010 license, Endo can no longer exclude impacts. That proposition is recognized in this court's case, which is discussed a lot in the party's brief, the Studien-Gesellschaft Code case, or SK for short. When a patentee gives a license to a licensee, it can no longer keep that licensee off the market. And so that distinguishes this situation from a situation where a licensee had no ability to be on the market. And so that's what makes this particular situation unique and different from what might be called.
It doesn't seem to matter, because I thought, if I understood your questions earlier, that doesn't matter, because even had they never, if Impacts had never been on the market, they just up front in 2010 said, all right, you've challenged my patent, you're doing the Hatch-Waxman thing, I get it. We're going to do a settlement agreement right now in 2010 that says you can go on the market for the first time and you go on exclusive, and you have that exclusive market even as against me, the patent holder, until the end of the patent's life. We'd be in the same boat. You'd have the same issues. You'd have some different facts.
You have some different
Maybe
facts.
intent's a little hard to prove, I don't know, but you legally, they are in the same boat, because you have two competitors agreeing not to compete and to instead create a monopoly from which they both benefit.
That is correct, Your Honor. And it's a concern because at that point, the monopoly is not coming from the patent. The economic monopoly is not coming from the patent. It is coming from the parties' agreement.
It is coming from the patent, because it's somebody is going to exploit the patent. The patent holder can, nobody disputes. You don't get antitrust scrutiny if the patent holder decides not to license, right? If the patent holder just decides to practice the patent, I don't even know if I'm using correct verbiage in the IP space. I don't know that space, but if the patent holder just decides to, I think, practice the patent and then produce the product, that's not subject to antitrust scrutiny.
No, in that case,
So then
Your Honor,
if that's true, then if the patent holder just says, okay, I'm not going to do it, you're going to do it. And I'm not going to get in that space. It's just you're going to substitute for me. And isn't that the exact same thing?
No, Your Honor. There are two components to my answer to your question.
Okay.
The first is that the patent monopoly granted by the Patent Act doesn't mean that the patentee gets to exercise monopoly in the marketplace in the antitrust sense. It may be that there are products that compete with the patented product. And that's significant here because Impax had this license. Impax had a product that competed with Endo's patented product. And so Impax was no longer within the exclusionary potential of Endo's patent. So it's just not a mere exercise.
Now you're getting into separating the 2017 from the 2010. And I thought your answer was pretty clear to me that it wouldn't matter whether Impax was already on the market. What matters is that two competitors have put their heads together and created a monopoly, an exclusive, I mean, it's almost, I'm being redundant here, an exclusive, but a really locked in monopoly with a non-compete agreement. And you've got, unlike activists, you've got every sign this is a good, solid patent. It's been held up many times. There's no reason to think anyone else is going to be able to break it. It's a good, solid patent. So it doesn't matter that Endo was already in the market, I think, under your theory. The fact is you got the two competitors agreeing to create this monopoly, lock it in, and share the profits. And we'll send that price soaring up.
Yeah.
And we're going to share those profits.
So, Your Honor, I was attempting and perhaps did not do a good job of addressing Judge Srinivasan's question about the impact of the patent. And doesn't that just give this right to monopoly? And the fact is, it provides the ability for the patentee to have a monopoly over the patented product. But it may be that there are products that do not infringe that patent. So going back to your hypothetical, Judge Millett, yes, a very solid patent in terms of having been found valid in multiple cases. And in fact, there are multiple cases here. But it's not just patent validity that matters. If you read activists, they also talk about patent infringement. And a concern arises is if there is the removal of uncertainty regarding infringement, and you remove that uncertainty by entering into an agreement not to compete and to share the resulting monopoly profits. That's also an antitrust concern. So that's what was going on here, Your Honors, is that.
Oh, but under this agreement, you could still have other drugs come in that can compete
Without,
with, right? With Opana, is that how you pronounce it? Opana. As long as they don't infringe the patent. So you've got the same, they've got no ability to wall off, Opano-like but not infringing products. So it's exactly the same as my do it all in 2010 hypothetical. There, or in this two-step that's happened here, they've created a monopoly over Opana or the generic equivalent of it, the extended release generic. That's locked down, and that seems pretty solid. But the ability to compete around it remains the same, whether it's a 2010 agreement or a 2010 plus 2017 agreement.
Your Honor, we would need more information about the relevant market and whether, in fact, there were other products that could compete against Opana ER without infringing the Opana.
Is your theory in this case that the 2017 agreement went beyond somehow and somehow prevents competition even of products that would not infringe the patent? Have I misunderstood you all this time?
Yes, Your Honor. If we define the market as the market for Opana and generic versions of Opana, this agreement affects that marketplace. Now, there could be another set of.
The whole point of generic is that it's equivalent.
I'm sorry, Your Honor?
The whole point of a generic is that it's equivalent.
That's right.
And it would infringe the patent, right? To do it. The first year Opana was out, and Endo was marketing it. If someone came up with a generic bioequivalent drug and marketed, they would have infringed the patent.
Yes, unless they had a license.
Right,
the way
without
that
the
Impax
license,
had
for
a
sure,
license.
for sure.
Right.
Right. So all that's been locked down, as I understand it, between the 2010 and 2017 agreements put together is Apano and its generic equivalent. That's locked down, right? And you say that is
So
different?
the agreement creates a monopoly in that market
Mhm.
because Impacts had this license to be on that market without infringing
I
Endo's
guess
patent.
I don't understand the concern about non-infringing products because I thought all a license gives is a license by definition only makes sense with respect to something that could infringe. If it's not infringing, then you don't need the license anyway because you're not infringing the patent. So isn't whatever was being licensed in 2010 and 2017, aren't we presupposing that the license is coterminous with the scope of the patent? Why are we even talking about non-infringing products? Because you don't need a license, do you?
When we think about a scope of the patent, Your Honor, we think about its exclusionary potential. And once a patentee grants a license to a licensee, it can no longer exclude the licensee. And so at that point,
But it could never exclude the licensee if the licensee weren't infringing anyway.
I'm sorry, could you repeat the question?
It could have never excluded the licensee if the licensee weren't infringing anyway. Because you don't even need, then the license is irrelevant. If I make a product that doesn't infringe a patent, I don't need a license to make the product because I'm not worried about it.
Right. And in that situation, Your Honor, if the patentee agreed with a competitor who produces a product that does not infringe, that very much is an antitrust concern and should be subject to rule of reason analysis. And in fact, that's what we have here. Impacts' sales of the generic do not infringe the Endo patent because of the license. As this court recognized in its SK decision, when a patentee grants a license, the patentee can no longer exclude the licensee. And at that point, the licensee becomes like a competitor in the marketplace. And so here you have those two competitors coming together, agreeing to share monopoly profits, and consumers pay the price. And we just seek the opportunity to show that that agreement violates the antitrust laws, that an agreement like that is not immunized from antitrust scrutiny.
Okay.
And I just wanted to ask you, this is under a 12B6, and we haven't talked about Iqbal and Twombly. And
Yes,
should
sir.
this have been analyzed by the district court with respect to the elements of the Sherman Act, sections 1 and 2?
I didn't hear quite the last aspect of your question.
Yeah,
I'm sorry.
I mean, we're here under 12B6, and so Iqbal Twombly could come into play, but
Yes.
we just haven't spoken about that in terms of whether or not the district court should have analyzed the allegations with respect to section 1 and 2 of the Sherman Act.
Right, Your Honor. And our argument in our brief is that the district court failed to do that. It failed to credit and accept as true our allegations about the license, about the representations that Endo and Impacts made regarding that license, about the right it gave Impacts to be on the market, but instead leapt ahead and ruled based upon the parties' justifications for why they should be allowed to do this. They put forward that, well, we had this dispute, we should be allowed to do that. Well, the parties in the rule of reason analysis will have the opportunity to forward their justifications as part of the rule of reason analysis. It's in step 2 of that rule of reason analysis. But we, as plaintiffs, have no obligation at the motion to dismiss stage to disprove parties' pro-competitive justifications. So just with respect to Iqbal Twombly, the district court did not assume our alleged facts as true and rule on that basis. Instead, it jumped ahead and ruled based upon, granted the motion to dismiss based upon the parties, basically the parties' justifications for this agreement. And that only happens once we get to page 2 of the rule of reason analysis. And we'd like that opportunity to actually get to that stage as part of the, hopefully a remand if you agree with us that the district court erred here.
And in your complaint, are your allegations about what Impacts got under the 2010 agreement, are those allegations of fact or allegations of law?
The allegations about what Impacts received as part of the 2010 agreement. Well, those are allegations of fact. I mean, the fact that there is a license, that's a fact.
But what that contract gave them
the contract in very uncertain.
it sounds like a question of law.
Yeah, no,
I'm having trouble sorting it out.
Well, so the contract itself, in terms of the provisions itself, it says we grant you a non-exclusive royalty-free license. That is a fact. Now, if there is a dispute about what that means, and you have to construe the contract, well, then we get into some questions of law.
Okay, so then your allegations about what they got under the 2017 agreement, what impacts got under the 2017 agreement, those are also, and if there's some confusion about what they were getting, I mean, you have to really compare the 2010 and 2017 both to figure this out. That's what your argument has been all along. And you have to look at what they got in 2010 to figure out what they were getting in 2017. Are those not questions of contract law that a district court does not have to, view in the light as facts in the light most favorable to the plaintiff?
Questions about contract law in terms of, say, the validity or whether or not the 2017 agreement was reached, this court does not need to resolve those to rule in our favor regarding what were the rights that Impacts enjoyed under its license. It's clear that Impacts had a license.
But if the whole point of the 2017 litigation was by Endo to challenge what Impacts thought it had under the 2010 agreement, that's why I'm having trouble figuring out how to apply, as Judge Child said, how we apply pleading principles when the whole point of the 2017 litigation was that we disagree about what you got with respect to, I guess, what's been called the future patents in the briefing. We dispute what you got as to those under the 2010 agreement. Right, so is that, to the extent your complaint says, this is how we interpret that situation, is that something the district court has to credit to you and assume you're right on, or does the district court have to say that's a legal allegation that I can resolve right now as part of the motion to dismiss?
So, Your Honor, the only allegations in our complaint that concern the 2016 agreement are the fact that there was an agreement, that agreement involved royalties and did not seek to.
No, you have allegations about, based on, that's why I said it's a 2010 and 2017, what did you get from 2010? Seems to be, you put a lot of weight on that because you have said many times in this argument, and many times in your brief, they got from 2010 the right to be on the market and stay on the market, and nothing in the 2016 litigation was going to change that. But of course, Endo's complaint in 2016 very much seemed to dispute Impacts' ability to exercise the future patents, what is called the future patents, but patents that Endo held over this product. And so how do we look at those? What is our review for how the district court understood that, that dispute about what Impacts got in 2010 with respect to the future patents?
The dispute about that from the 2016, from the 26 litigation, that dispute and resolving that dispute, including the factual and legal issues in that case, are not appropriate to be considered as part of whether or not our complaint stated a claim.
Because
of the fact that that is part of the party's justification for why this agreement does not violate the antitrust laws. And one does not get into the justifications for an agreement until step 2 of the rule of reason. And our obligation as a plaintiff under a rule of reason case under section 1 is to allege market power and competitive.
We don't get to rule of reason until first, right? You have to allege up front improper exercise of market power, correct? You have to do that up front in your complaint to state a claim.
We have to state market power and the fact that the exercise of that market power had anti-competitive effects.
Right.
Yes.
And so if one thought that understanding or resolving this dispute about what they got under the 2010 agreement involved whether or not they had the market power they thought Impacts thought it had. And it would go to your statement of a claim, not to the rule of reason defense, would it not?
It does, our claim, and again, we just have to state a plausible claim that Impacts had a right to be on the market. And certainly based upon the license and based upon the fact of what the parties themselves said in two other litigations before federal tribunal.
But also you have to include what they said in the 2016 litigation too. You have to look at all three litigations.
There was no determination that 2016 agreement, 2016 litigation really threatened Impacts' right to be on the market. Recall that we alleged that the parties in
Double damages would be, I'm sorry, I guess General Counsel came to me and said, I'm facing treble damages under Federal Trade Commission Act or the Sherman Act, however you want to characterize it. Is that serious threat, something I should take seriously? I'm going to say yes.
In another case, perhaps so, but the party's conduct here does not, and particularly Impact's conduct here, does not suggest a party that was fearing for its ability to be on the market. It's important to note that.
So we have to assume, so do we have to, so the allegation is we assume they settled the litigation to create this monopoly and not to eliminate any risk to, any litigation risk for Impacts. That's sort of part of your case. They didn't have any real threat. All they did was use this as an excuse to set up this monopoly.
Well, Your Honor, under activists, if they use this agreement, and we think they did use this agreement to eliminate the risk, the competition risk facing them, and agreed to create a monopoly and share monopoly profits, under activists, that is the relevant anti-competitive harm. So even if you credit their claims now that Impacts' right to be on the market were in dispute, settling that dispute by agreeing to share monopoly profits with just one of them remaining on the market, that is a relevant antitrust harm under activists, and we'd like to be able to make that case on remand.
Let me make sure my colleagues don't have additional questions at this point. We'll give you a little time for rebuttal.
Thank you very much, Your Honors.
Mr. Gordon.
Thank you, Your Honor. May it please the court, George Gordon for the appellees, Endo Pharmaceuticals, Inc. and Endo International. The problem with the FTC's position in this case is that it has no real limiting principles. What we just heard from counsel was that all they have to plead is market power and conduct that creates a risk of an anti-competitive effect. And here, what they've pled is that Endo and Impacts entered into agreement with the patent holder, Endo, chose to allow Impacts to be the only one practicing the patent to the exclusion of both itself as the patent owner and others, other potential licensees. That describes literally every exclusive license. And the Patent Act is...
No, it doesn't describe exclusive licenses, which they say, at least the majority are vertical as opposed to horizontal competitors, or involve other types of agreements that aren't between two head-to-head direct horizontal competitors.
There are certainly vertical agreements. I'm not in a position to say and don't believe as a matter of fact, but I don't think it's relevant to the court's decision, that those are the majority. There are plenty of
Well, you just said
examples.
every exclusive license. I was just trying to clarify that. I understand their position. They're only talking about exclusive licenses between two head-to-head horizontal.
No, because I'm also talking about the kind of exclusive license that was issued in a Studian Gellenschaft case from this circuit, where the court recognized that even though it was a vertical license as respect to the licensor and the exclusive licensee, it did actually have very clear horizontal competitive effects because it also excluded other horizontal competitors from the relevant market, having the effect, just as the FTC alleges here, of raising prices and allowing the patent holder and the exclusive licensee to share monopoly profits, which again, so really what the FTC's position would require in order to escape scrutiny under the antitrust laws is the exclusive license would have to be for a patent that neither the patent holder can actually or potentially practice, or any other exclusive licensee can actually or potentially practice. That is a very rare thing if it exists at all, Your Honor. So I think that the difference between the vertical and horizontal is more than a bit illusory in this case, and frankly in any case, because exclusive licenses, even when the patent holder isn't or has chosen not to practice the patent, still have a horizontal effect with respect to other licensees and the patent holder itself, if the patent holder could choose to practice the patent but decides not to.
I just want to ask you about the theory of the 2016 complaint. Was it Endo's position in that complaint, in that litigation, that the alleged breach of the 2010 licensing agreement invalidated the license?
It was Endo's position. It had sent a notice of termination, but the license had not terminated. It was Endo's position that the royalty negotiation, the royalty payment was a condition of practicing the license, so that if that condition was not satisfied, there would no longer be a license that Impacts was practicing under, which is why, in addition to the breach of contract claims, Endo did bring patent infringement claims as well.
Right. So just to answer just more directly for my purposes, Endo's position was that the alleged breach, the failure to negotiate over the royalties for the future patents, I think that's what y'all call them, was a breach, or if they didn't start negotiating right away, would be a breach and they would lose their license?
The license would no longer be effective. That's correct.
Okay. And the argument was that they had already breached it by not negotiating, or was the point of the litigation to prompt them to negotiate? That's what I'm trying to understand from the answer you just gave me. It was already breached. So
it was already breached.
In Endo's view, at the time of that litigation, they had lost the license.
They had lost the right to practice the patents, correct, Your Honor?
They had lost the license?
Lost the license, yes.
Okay, thank you.
So, and as you just mentioned, another aspect of the 2016 complaint by Endo was an allegation of patent infringement.
Yes.
So, with respect to that, I don't think this is the FTC's theory, but because Endo had alleged patent infringement, then does that bring into play activists' concern that sometimes you could have parties enter into a settlement where the validity of the patent is an issue?
No, because the validity of the patent had already been tested and the patent had survived the testing.
But you alleged patent infringement, and so it was definitely an issue in that case.
Well, Endo's position would be validity wasn't actually an issue because it had already been tested and survived the validity challenge, including validity challenges by Impacts, because while Impacts was not in the litigation, what we call in our paper, the Southern District of New York litigation, with respect to its original formulation of oxymorphone ER, it was in that case with respect to its crush-resistant ANDA of oxymorphone ER. But more importantly, Your Honor.
Wait, so I'm sorry, I don't want to interrupt. Was Impacts also marketing the crush-resistant?
No, it never. It did not launch the crush-resistant. Only the original version. More importantly, Your Honor, is there was no payment. The concern in activists was that there was basically a payoff, right, by the patent holder to stop a pressure testing challenge to the patent to protect a weak patent, I think is the majority called it. There's no payoff here from Impacts, from Endo, the patent holder, to Impacts, the alleged infringer. In fact, the royalty went the other way. What happened here was there was a dispute over whether or not Impacts could practice the patents without paying a royalty. The parties had that dispute. The court recognized that Endo's position survived a motion to dismiss, and the parties settled that dispute with Impacts agreeing to pay a royalty.
But there was a payoff in the grant of the license.
Well, it received in return for that what Endo had the right to give, which was an exclusive license.
Right.
Right. So there's nothing. I think it was Judge Millett that used the term was there anything kind of suspicious about the 2017 agreement? The way the majority in activists anyway seem to think that the reverse payment was suspicious. And the answer is no. Impact's got a resolution of its right to practice under the patent, and it got what Endo had the rights under the
I think it would have been a different theory. I guess my question is, if the FTC brings a complaint that alleges that there's something suspicious because the patent was in issue in 2016 per your own allegations, and I take it Impacts didn't agree that they had infringed the patent. We can ask them, but
that's correct.
I assume that that's so the validity of the patent that was alleged to have been infringed in 2016 was an issue. And if somebody styled a complaint that said that's an uncertain patent, all you got to do is look at the litigation and see it was an issue. And we're concerned that the way this resolved is suspicious in the same way that the activist majority was concerned about it. Then why isn't that just at least a viable theory? I'm not saying that's the theory of this case. I don't think it is.
I'd say two things. If the FTC thought that was a viable theory, but the FTC knows well how to plead a reverse payment case, it's played many, including FTC v. activists, it would have played a reverse payment case here.
Right. I'm granting you that wasn't pled here. I guess I'm wondering, though, why conceptually that's not possible.
Because there's no reverse payment. In FTC v. activists, you had both basically in the form of both cash and side deals, consideration going from the patent holder who was trying to protect its patent to the infringer. And the only thing coming back from the alleged infringer was we're going to drop our challenge, right? And so we're not going to pressure test that patent. This 2017 settlement is very different. It's very much like, as Judge Lamberth recognized, the kind of commonplace settlement that the majority described in activists, where Endo believed and stated a claim that Impacts owed it royalties to practice under the patents. Impacts settled that case by agreeing to pay royalties to practice under the patent. That's not a reverse payment. It's not a payment to protect the weak patent. And there's no reason to believe Endo wanted to protect that patent. It tested those patents at trial, and it tested those patents all the way up to actually multiple trials, Your Honor, and it won all of them that went to trial. And it tested those patents all the way up to the federal circuit, and they were found to be valid.
I'm sure my colleagues don't have additional questions for you. Thank you, Mr. Gordon.
Thank you.
Hear from Mr. Lefkowitz now.
May it please the court, Jay Lefkowitz on behalf of Impacts, and I think I can be quite brief this morning because I think we've covered a lot of the ground. I'd like to just make a few observations in response to some of the questions that were raised by the panel. On your point, Judge, you asked about, well, if there was an alleged claim of infringement, doesn't this bring us into activists? And what activists was concerned about, first and foremost, the court said, it said, we're not addressing the typical case where the patentee brings in an infringement claim. They use the example for $100 and there's $40 paid. That's not an issue. We're concerned where the payment goes in the other direction. Here, of course, at paragraph 98 of the FTC's complaint, they allege that the net present value of the payments in this case, payments from Impacts to Endo, were over $250 million. That, of course, is the best evidence this is the typical exclusive license. And Judge Millett raised this question as well. She said, well, what was the situation after the judge's motion to dismiss rule? And of course, as you pointed out, they were scared. They had a suspended license. The court had said this claim can proceed. They were facing in the complaint enhanced damages. This is at 25 of the complaint. Further equitable relief also at 25. And of course, it had survived the motion to dismiss. So they settled.
The complaint you're talking about is Endo's complaint.
Endo's complaint back in 2016. That's what was at issue. So to say that they had a risk-free license and to say this court where Judge Lamberth had to accept that as true, that just makes no sense. He was entitled, clearly, leaving aside whether it's a legal conclusion or not, and I think that's fair question. He was entitled to look at the public record that the allegation that Endo made survived the motion to dismiss. So we're in a situation where essentially we have, as you pointed out, Your Honor, right at the beginning, a garden variety exclusive license. Now, Your Honor, Judge Millett, you asked at the beginning to the FTC, well, was it improper to settle? And they said, no, it wasn't. But their concern is we either, and we've heard two things, both today and in the brief. On the one hand, we've heard today it was improper to enter into that license in 2010. In their briefing, they seem to be suggesting that having given a non-exclusive license, they now couldn't change it to a more exclusive license. And I would simply point out, even in their complaint, they don't actually suggest that this is a true exclusive license. They recognize, I think at paragraphs 94 and 105, that it wasn't a pure exclusive license. If Impacts had stopped selling, if they couldn't get access to enough material, Endo could have come into the market on its own or licensed it to someone else. And as the DC Circuit said in the Studi and Giselle Chef case, one of the things we look at is whether a license is less than exclusive. That even makes it more competitive. But even if it's an absolute exclusive license, which this court in the 1981 case said was totally fine, the only question is, does something happen in Activist that changes that analysis? Activist was concerned, as I said, principally with the unusual situation, as the court pointed out in Activist, where a party with no claim for damages walks away with money simply so it will stay away from the patentee's market. We clearly didn't have that here, but there was another issue in Activist that we don't have here, which is the concern that the patentee is not only paying money to the generic to stay out, but because of the 6 months exclusivity issue, they're essentially icing out all of the other generics because having made a deal with the first filer, none of the other generics have the same incentive to even come and challenge the patent because they're going to be backed up behind this 6 months exclusivity. We had no such issues here. There was no exclusivity. Impacts had been selling this product for many, many years already. So I would say, and finally on this question of 12b-6, well, the judge took a look very carefully at the allegations in the complaint, and he went beyond what I think he even necessarily had to do, which was simply look and see that this is nothing more than an allegation of an exclusive license. He actually tested it as best as he could against the Activist factors, recognizing that without the 30 months, the 6 months exclusivity, you didn't have all of the factors lined up. And he said, and this is all at pages 211 to 217 in the joint appendix. He looked at it and he said, there's no question here of patent price fixing or cross-licensing. Those were the concerns that Activists addressed in terms of line material and Singer and New Wrinkle. None of those concerns, as Your Honor pointed out, Judge Millett, we're not going beyond the patent at all. He also said this is a traditional settlement, which the Supreme Court made clear in Activist, insofar as the dissent urges that settlements taking these commonplace forms have not been thought for that reason alone to be subject to antitrust liability. We agree and do not intend to alter that understanding. Activist was focused on something unique. And then the court recognized that Section 361 of the Patent Act and precedent allows exclusive licenses. So, Your Honor,
you get under the 2017 agreement? What right under the patent did Impacts acquire that it didn't previously have?
Well, because as the judge found, when Endo brought that lawsuit, they said your right to practice this patent continually with respect to the future patents is subject to the negotiation in good faith for new terms or royalties. And the fact that you have refused to do that when we made this offer of 85% and you refused and you kept selling meant that you were in breach of the contract, the 2008 contract, and therefore you are infringing our patents for the very same reason we thought you were infringing all the way at the beginning.
So what right under the patent did you acquire under the 20 that you didn't previously have? Did you acquire under the
We
2017 agreement?
acquired a new license, a license that had been suspended, and it was a license to practice.
Do you agree that the license was suspended during the
They-
litigation?
That was the theory of their,
I know, but I'm saying what its impacts is. I guess that was
Oh,
their theory.
well,
I assumed you kept selling through the litigation.
we did, but we
So
kept
you didn't
selling.
think the license was suspended?
Well, Your Honor, I think what happened actually was we did keep selling. They sought enhanced damages because of that, and they sought equitable relief. Parties are not obviously required to seek like a TRO to take you off the market. Sometimes patentees say, look, be my guest, you can
But I
infringe and I'll
phrased the
get
question the
double
way
damages.
I phrased the question the way I did. I think you described how Endo would look at the 2017 agreement, that now, okay, you lost that agreement, but now we're giving you a new one.
Our
Does
lady-
Impacts agree that it got a license it didn't have before under the patent
I think
in 2017?
Impact's litigating position was, look, we're entitled to this, and we don't have to negotiate a new license. But once the trial judge said, you know what, that's in question, their complaint stands, it survives the motion to dismiss, there was an enormous amount of threat. And
Right, so you got
we
certainty
got
and stability,
certainty, and I think we
but
got.
that's not a right under the Patent
I
Act.
think we got a license. In fact, I don't think there's any way to look at the 2017 agreement and not say it is in fact a patent license. And it's a somewhat different patent license than the one that we believe we
So you
got
got
in
a
2010.
new patent
A new
license,
patent
even if, or a replacing patent license, even if you thought the other one continued until that moment.
Correct. And the court, and just to make this last point, parties, even parties that compete with each other, that have complete freedom to operate with as joint patentees can license to each other. And in the Sixth Circuit, the Miller Form case made clear that a patentee can actually take away a license that it is granted if it wants to simply compete more rigorously with its former licensee. And while in that case, the court acknowledged it might have been a contract violation, the parties might have been breaching a contract, it raised no antitrust concerns.
And the reason you call it a new license, there was obviously an agreement on the royalty rate, and in the 2017 agreement.
Correct.
And is it your conceptual sense that whenever there's an agreement on a royalty rate going forward, that necessarily means it's a new license?
No.
Because you could also consider it just to be a fixing of a royalty rate for a license that already existed.
You can certainly, Your Honor, amend a license. Parties could have a license and then they could amend it based on future facts and circumstances. And frankly, that's, I think, initially what Endo sought to do. They said, look, you have a license and we want a new royalty, but they also said you have an obligation to do that. And if you don't agree, then we're going to treat this as infringing our patent because we're going to say you've breached. And while we strenuously objected, once the federal judge issued his ruling and said that's a viable claim to proceed and we're facing treble damages, then we had to essentially negotiate a new license.
Was it unusual that Endo's complaint didn't seek an injunction, even at least a permanent, maybe not a preliminary one, but its ultimate relief, a permanent injunction against marketing?
It did seek at paragraph 25 of the complaint, not only enhanced damages, but further equitable relief. And I understood that further equitable relief could mean to take us off the market. I think.
Was it unusual for them not to have spelled out in their complaint for relief in a context like this, an infringement case, a request at least for a permanent injunction?
I've seen cases where patentees try to take the competitor off the market immediately. But
I'm not talking about a preliminary injunction. I'm talking about an complaint relief at the end of the case.
I think they're framing. No, I don't read anything into that. I think they raise.
You've seen other complaints that involve infringement where the holder of the patent has not included a request for relief at the end of the case. People maybe not want to fight about preliminary injunctions. That's always hard.
Well,
at least at the end of the case, if I win my case, I want you to enjoin them from marketing.
Well, I think the further equitable relief speaks to that. And
I understand that you're reading for further equitable relief. I'm asking you, is that I don't do patent law, right? You do more of it. There's no doubt that you do more of it because you've done one. That's more than me. So Is that commonly how this is in complaints, or is it much more common for them to have that line in there? I sure, if I were the lawyer drafting that, I'd be very
I can't
nervous. My
speak-
client's gonna be
I
very
can't-
mad at the end of the day if district court goes, you didn't ask for it, so you're not getting it.
I think, I can't speak to why Endo said we want further equitable relief and didn't specifically say at that time. They would have been entitled in the course of the case to specifically define the equitable relief they wanted. But also, they were confident. They had just prevailed. The patents had succeeded and been affirmed by the federal circuit. They might have felt, look, we're racking up treble damages on every dollar they sell. Let's let them stay out there for a while and we'll take them to the cleanups.
Okay, thank you, counsel.
Thank you very much, Your Honor.
Mr. Hegedus will give you 3 minutes for rebuttal.
Thank you, Your Honors. I'd like to start with that very last point about Endo just leaving impacts on the market while the impacts accumulates all this damages liability. Endo approached impacts to settle this case. Impacts approached Endo to settle the case. That definitely suggests that Impacts had confidence in its position despite having lost on its motion to dismiss.
Would your case be any different if it had been the other way around? Would your case be, is that at all material to whether you've stated a claim of antitrust violation here, or Sherman Act, or Federal Trade Commission Act?
It goes to this question of whether or not our allegation regarding Impacts' right to be on the market is plausible. And so the conduct of the parties suggested that Impacts really much believed it had that right. In addition, I'd like to point out,
does it affect it doesn't affect your legal position whatsoever, your legal theory at all?
it doesn't affect the legal theory at all. It goes to whether or not our complaint plausibly alleged that Impacts had a right to be on the market. I would like to address, though, this question of the unusual nature of the agreement in Activist versus this one. One of the keys in Activist was the fact that the generic received a payment from the brand, and that was deemed to be unusual. There's some very unusual aspects to this agreement as well. To begin with, this was a dispute about royalties, and out of that dispute, in the settlement of that dispute, Impact received monopoly. If Impacts had prevailed in the litigation over the royalty rates, Impacts could not have obtained a monopoly. So that's highly unusual. And so to say that this is—
If they had prevailed, Endo couldn't have gotten a royalty either, right?
Oh, that is correct, Your Honor. It would have been a continuation of the status quo, where Impacts had a right to be on the market. But Impacts coming out of the settlement with a royalty was highly unusual. And so it makes it comparable to what happened in the Activist case. Another thing I'd like to point out with respect to Activist is the fact that the uncertainty is not just about patent validity, it's also about infringement. And here we had uncertainty about the respective competitive rights of these two parties, and they settled that uncertainty by agreeing to a monopoly and sharing monopoly profits. And that is the relevant anti-competitive harm under Activist.
Can you ask me, tell me how would you deal, if you're right in the opinion with, in your favor, with the Supreme Court's decision in Westinghouse, which Activists reaffirmed, and that was an agreement not to compete between two direct competitors, a patent holder and a direct competitor.
In that situation, GE licensed Westinghouse to be a producer for it.
A direct horizontal competitor.
No, there's actually disagreement about what was going on in that case. Many people view that as having been a vertical agreement.
What did the Supreme Court treat it as?
The Supreme Court allowed it,
Treated it as a horizontal agreement between two direct competitors.
The Supreme Court has not clarified that. They kind of say, okay, well, we know there's this GE case out here, but in these other cases, the GE case has come under a great deal of scrutiny both by courts as well as by commentators. The Supreme Court has never overruled it.
So we're bound by, and they cited to it again in activists. So we have to read activists with Westinghouse, taking Westinghouse at its word, every word. And that's what I'm asking you to reconcile.
Right. But this is not the GE Westinghouse situation.
Okay, oh, now,
Because of the competitive relationship that you have between Endo and Impacts, my understanding of
GE and
the
Westinghouse didn't have a competitive relationship.
Westinghouse needed to be licensed in order to exercise that patent, in order to produce those light bulbs. Here, we have a situation where Impacts is already on the market via the 2010 license. And thus, they have this horizontal, fiercely competitive relationship that did not exist in the GE Westinghouse situation. But fundamentally, and here the court's decisions in Studien Gesellschaft Cola supports us, is that we're asking that this agreement be subject to antitrust scrutiny. This court subjected the vertical agreement in the SK case to antitrust scrutiny, to rule of reason analysis. And all we're asking for here is the opportunity to present our case under the rule of reason. And we would ask you to please remand the case, reverse remand, and allow us that opportunity to make our case.
Thank you, counsel.
Thank you.
Thank you to all counsel. We'll take this case under submission.